Welcome to Inside with Savvy and Sage. I'm Rob, bringing my partner Chad Tongo. So, Chad, attorneys,
We love them.
we
We
do.
just can't get away from them.
Yeah. Well, so you know the old saying. You know, actually, it's a joke that very few attorneys laugh at when I tell them this joke, but it is kind of funny to people
Dad
that are.
joke. Here we go.
Yeah. So, what do you call a bus full of attorneys going over a cliff?
What?
A good start. Yeah. But our guest Rob Scott is not one of those. He's actually a great guy and very grounded and looks after not only people but looks around the corner and anticipates things going on, which is crazy important in the world of technology because things move so fast. And he was one of the first. I mean, one of the first attorneys to really specialize in technology and as an authority. So I'm really looking forward to having a dialogue with him.
It's going to be an engaging one.
Yeah. All right. Let's bring Rob on. All right, Rob Scott, technology lawyer. Boy, there's a lot to talk about today, and we're going to touch on a number of subjects. But give us a brief. Obviously, with your age, because you're an old guy like me, You didn't start off probably in technology. So how did you become? Now, how did you not only get into technology but become the authority? Because a lot of people turn to you in a lot of different respects in technology.
Well, I was lucky. I graduated law school in 1999. And at that time, the world was ready for technology lawyers, but there weren't any. And so I was one of those guys that just happened to get out of law school at the right time, happened to get on early with clients that were in IT hosting and other related services, and just always had an interest in personal computing myself. I had one of the Commodore 64s on my desk when I was in high school. I thought AOL was the second coming of the most highest tech thing I had ever seen in my life. And so for me, it was just in part being in the right place at the right time. And then my firm, the lawyers that I associated with at my firm, because we were focused in IT, we started getting all the biggest names in tech, both from the big corporations to the small service providers and everything in between. We developed an international reputation as the sort of go-to boutique firm for niche computer law problems like software disputes or software licensing projects or IT outsourcing or IT procurement projects or litigation involving IT firms or technology. And so because of that experience, by the time I'm 53, after you do that for a couple of decades, you really learn a lot about a lot of things. And as a result of that, we launched a SaaS solution called Monjur in 2022, which was a first of its kind AI-powered SaaS-enabled legal service, which takes the templates that we developed over 20 years and 500 engagements and delivers them to clients as a legal service, but through the cloud. And in a way that instead of the old way we used to do things is we would email clients Word documents, and those would be our deliverables. Today, we deliver our deliverables through smart hyperlinks that integrate directly with our clients' CRMs and sales quoting tools, so that when their end user customer enters into an agreement, a license agreement, an IT services agreement, we bring the legal contracting solution directly into the sales process. And when the quote, order, or proposal is entered into online, all of the legal terms and conditions are entered into online as well. And because we're hosting them, we're also able to keep them dynamically updated with new legal protections or changes in the law that come about, in fact, quite frequently when you think about privacy regulations that could affect IT service providers and SaaS firms. We've got a whole patchwork of state laws that are coming out on a regular basis that affect the types of customer contracts that IT services firms and SaaS firms need to have as part of their customer contracts. So mine was a journey of representing software firms representing managed services firms and figuring out a way to take what I was doing as a lawyer, as a traditional, hourly billing and fixed price billing, and create a solution that democratizes the legal services that our little boutique firm was offering for tens of thousands of dollars up front, and now making it available to many more MSPs and other service providers through a SaaS platform that allows us to deliver at scale and in a fraction of the time that it used to take us.
Right. And meeting people where they're at. So we'll put a link for Monjur in the video so people can get there. And this reminds me of the conversations Chad and I are having with the big banking institutions about how to use our 3D environment to capture the attention of the Gen Z and millennials. Because I don't know, the last time I walked into a bank, I don't know if I saw anybody under the age of 40 in the bank. They just don't go, right? So here you have all these technology clients that are not going to show up at your lawyer's office, right? And they're just not going to communicate with you that way. So you've created Monjur as a way to connect and deliver in the capacity that they're looking for, right?
Yeah, it's a much different even process. Once you start rethinking your traditional legal service or any professional service as a SaaS offering, they say that SaaS stands for, it doesn't stand for software as a service, it stands for success as a service. And so when you start migrating from a mindset of I send you a Word document and I earned my fee, to a concept of we want to help you win more deals and make sure that you have comprehensive legal protections across the board that are standardized, that you can keep updated, it's envisioning a much different way to help a client when you start thinking as a SaaS offering as opposed to just a traditional legal service where you're selling hours or you're selling deliverables. And it really was evident to me when I had one particular client that was with me for a while. He signed up for our Monjur platform and we needed some feedback from him on his documents, and I called him repeatedly. And I finally got him on the phone, and he was very apologetic about not getting back to me and was telling me how busy he was. And I said to him, frankly, I don't know why I'm calling you. I have all your money. The ball is clearly in your court. You're not looking for me or waiting for me for anything. It's amazing that I'm even on the phone with you. But the reality is as a SaaS business, I need him to be fully onboarded so I could get him off my onboarding project list. I need to get his days to onboarding down so it reduces my total number of days to onboarding. And I need him to be very happy in using the tool and engaging with it by the time his renewal comes up, or he's going to churn. And so just an example of a conversation about how your mindset can shift based on your business model. And for us, shifting from a legal services business model, which frankly is a little antiquated, not Gen Z and millennial friendly in any way, and is based on deliverables that can easily disconnect from value. Rethinking your solution, your service, our services as a SaaS company has tremendously helped us with our client satisfaction, with our ability to onboard successfully way more clients per month. For example, in our contracting business for managed services, we were doing about 4 engagements a month before we started Monjur. We're now onboarding 35 to 40 new clients onto that platform a month. And they're all, extremely happy. They're all, very satisfied with the services that we're offering. And we're doing it at a much higher volume, and we're still delivering it at a fraction of the time and cost that what it used to be for us. And I think that these are the keys, is that once you start thinking about a SaaS offering, now the burden of automation, efficiency, all of those things that you guys focus on with your development teams for your environments, those are on you, right? The customer is going to pay a fixed price, and you're going to make them have an incredible environment that transforms the way they interact with their customers and consolidates all this different noise that everybody's dealing with and makes it more personal and more enjoyable. And you're going to invest a lot of money in making that happen for those users to have that experience. And what you're really selling them is a vision, an experience, a concept, a new way of working. And so often SaaS businesses really solve a problem and show people a new path about how to handle problems that they were dealing with before. And frequently, once they see the new path, they never understood how they lived without it, right?
Right.
We all have those tools in our life that we think, man, how is it possible for us to get by with before we had this? So it's really neat to see. I'm part of the SaaS Academy, which is a group of 800 fellow SaaS founders. And that community, everyone's doing very well. People are growing. It's a really cool time to be in the software as a service business because it is now a model that's well embraced across different sizes of business from SMB to enterprise. And if you've got a solution that you can bring to the market that you could solve for 500 people, there's a good chance you could solve it for 50,000 people. And the economics of that and the potential of that, as Chad well knows from his background in PE, that's very exciting to people in finance and investors and potential buyers. And because of that, successful, rapidly growing SaaS businesses can be very lucrative to grow and sell. And so there's a lot of interest in people developing SaaS. And with the invention of the large language models now, everybody's scrambling to see how AI is going to fit into what they're offering. And so that creates a whole new dimension of excitement and opportunity for all of us that are in the business.
A big part of what Rob and I are running into on a day-to-day basis and the conversations we're having is, how industries are obviously being changed, affected both negatively, positively, some may argue, with the introduction of large language models. And there's a massive misconception, within at least from a public standpoint, that, large language models are almost kind of an all-inclusive solution, oriented type of, technology, right? As long as they can tap into integrating, the likes of OpenAI's ChatGPT or Gemini or whatever is existing out there, they're going to be able to somewhat make that work in their respective business models. Now, pivoting it towards your expertise in law, and technology and SaaS products altogether, what are the kind of big topics right now that you are having to tackle and deal with as on a day-to-day basis with regards to AI and integrations thereof, from privacy, copyright, all kinds of stuff.
So you hit the nail on the head. Let me just start with the important intersections with legal when it comes to AI. Number one, the contracts that people use for SaaS and IT services were built in the pre-AI era. And so we have separate agreements for IT services involving AI. So we have a service attachment for managed AI. This would be for service providers that are helping customers with products like Microsoft Copilot, custom GPT development, anything involving large language development or consulting workshops, procurement. Those traditional IT services agreements don't come close to handling the legal concepts that are new and unique to AI. Similarly, in the context of software, if you're transitioning from a cloud-based solution with no AI and you're merging with an AI-based solution, traditional software licenses are not going to have, for the same reasons I mentioned about IT services, the appropriate provisions involving AI. And I'll give you some examples. Early on in my journey studying the legal issues involving AI, and this is pre large language, we had to identify different what we call artifacts of intellectual property. In the software world, you understand that the code itself is IP, that may be patentable subject matter. It's certainly copyrightable subject matter. And so when you start thinking about the code, there are ways to protect it. But in traditional software licensing, from an IP law perspective, all of the IP was there on the table at the time that you signed the agreement. What's unique about AI is there are IP artifacts that don't exist at the time of the agreement, such as the learnings, such as potentially the input data, certainly the output data. These are all unique terms of art now that identify the artifacts of intellectual property that need to be allocated in terms of ownership and responsibility in the license agreement or a service agreement. Those concepts didn't exist in traditional services or licensing agreements. And so they need to be wholly new. Another example, which is very important in AI, and it could be a topic of itself, is the notion of responsible AI, which is something that I think all of us owe to future generations, to not get involved in projects where both sides legally are not committed to the principles of responsible AI. And so in our agreements, the provider is committed to principles of responsible AI, and the customer is also committed. These are not concepts that are in traditional SaaS agreements or traditional services agreements. So we really had to go back and think through what is new with AI and how does that affect potential customers on both sides of the transaction, to make sure that from a legal perspective, we're doing a good job of covering as many of the things that could go wrong as possible, right? And so that's one of the challenges. And then getting back, Chad, to the misconceptions about AI, I think that they run in a lot of different directions. But one of them is that, you just plug this thing in and then magic, you're good. That is not the case. The other one is that AI does not solve the privacy, security, and regulatory compliance issues of cloud. It just exacerbates them. And so regardless of whether you're in the cloud services or, starting to embrace what I call the AI era of IT services, it's very important that privacy, security, and compliance be front of mind when you're talking about how you contract with your customers and how you set up your system so that they can be compliant with the now myriad of regulations, both international, federal, and at the state level in the United States, that impact all of us in IT services and SaaS. And that issue is going to continue to plague us. And I expect a lot of very targeted AI-specific legislation to soon follow. And we're going to be dealing with all those regulations as well. So the compliance aspects of being in IT are not going away. If you're a SaaS or IT services provider, you're also going to have to be an expert at data privacy, security, and compliance to do a meaningful job at it and to be able to satisfy the regulatory obligations of the customer base.
Yeah, speaking of regulations, from your perspective, are we able to determine who the government's listening to? Because sometimes they make good law, and sometimes they pass a law, and you're like, okay, where did this come from? And then you realize some special interest paid a lot of money and got certain years to people. Where do you think the government is? Are they on a good track? Are they on a reasonable track, or is there a handful of really large companies that are dictating the direction?
I think it's a mixed bag on the track. I think we'd all be naive to think that it's not all about the money. And so I think there are special interests that are on both sides of the aisle that can affect legislation that will impact privacy, security, compliance, and AI specifically, and cloud and managed services more generally. I'll give you an example of what I think is really bad direction and bad policy. Recently, the Federal Trade Commission determined in its infinite wisdom that notwithstanding what might be in millions of contracts in various states, that it's decided that having a non-compete clause in a contract is no longer enforceable in the United States. To me, that is an example of a government going in completely the wrong direction.
Hmm.
And you'll know that when they passed that, that quickly went to court, and it's been paused, at least pending a judicial review of the propriety of that rulemaking. And so, in general, I'm concerned about an administrative state that usurps the power of the Congress and gets into rulemaking that otherwise should have uh, been part of the representative government, namely under the Constitution, was one of the separation of powers that was given to the representative branches of government, including Congress and the Senate, to make laws.
Hmm.
And so I'm concerned when agencies are starting to pass laws that can have that kind of effect on millions and millions of contracts that have already been entered into. So that's a sample of, I think, a bad direction. I think an example of a good direction is for the federal government to get more specific about creating ecosystems around privacy and security regulations, which I see them doing with CMMC and the DFARS legislation involving government contracting and the requirements of handling and safeguarding information. If you're anywhere in the supply chain for DoD, CMMC will apply to you. And what I think about CMMC is this: one, private-public partnership on the implementation and execution of the legislation; two, establishing a set of regulations that's built on existing industry frameworks, in this case, the NIST cybersecurity framework, which is well accepted and well documented, and you've got a whole group of people behind it, non-government people behind it. And so I would think that that's an example of a good policy. I also think that the government is doing some really good things when it comes to cybersecurity coordination and information sharing. We're part of many of the bulletins that get put out by the Joint Task Force. We frequently are getting updated on cybersecurity issues that pop up from the government with very good content and very good actionable things to know about. And so I think that the Joint Cybersecurity Task Force of the government are doing some good things. And so while I think it's easy to sit back and say, every government is corrupt, every politician has their hands out, and the lobbyists run Washington, while I think you'd be naive to, have to disagree with that. In total, I still think there are some areas where government has a role to play in all this. And there's a right way and a wrong way to attack some of these IT specific policies. And just based on what I know about the industry, I know the federal government and many of the state governments are reaching out to groups like MSP Alliance and others that are industry groups to get feedback on rulemaking and approaches. And again, I think that public-private partnership is the way to go. I personally, you didn't ask me this, but personally, I'm a fairly conservative-minded person. And so my idea of, government intervention is it should be used sparingly. And in many cases, regulations don't have the intended consequence. Would take the HIPAA business associate rules and the disclosure rules about your privacy. I mean, you go to the doctor, they have those forms there, they have to give them to you, nobody reads them. Are we really accomplishing anything with this notice and choice approach to privacy regulation? So I have my questions about, is it effective? What is it costing? Are we really protecting people? On the other hand, I see that cybersecurity risks and threats and the number of bad guys in the world is at an all-time high. and there is a role for government and law enforcement and otherwise to help us deal with that. And so,
Sorry for the interruption, but this is our shameless plug that if you like the content, like the interviews, please subscribe. And what else should people do, Chad?
Thumbs up, like, and share on all your social media platforms what we do here.
That was really good visual. People are going to be very impressed with how you coordinated your hands with your mouth. That's great.
Thank you. Hand-mouth coordination.
So it's interesting. So 2 points. One, we are bringing out a product in fourth quarter called Ephemeral, which is a completely secure, never happened, first ever conversation, direct message, video conference, and file share platform, right? That it never happened. That's why we're calling it Ephemeral. And as we're doing the research for it, we found that a lot of the HIPAA stuff, there's a lot of verbiage there provided by the government, but you look at it and it's still voluntary, right? So meaning you think, I think they're probably pretty good on the sharing of the files, but the actual conversation you're having with your doctor, that's not secure. It's just not secure. And so anyway, but talking about a conservative, this was interesting. So this was an excerpt that was put out by Devin Nunes, right, regarding Trump's media technology group. And I'll just read you quickly. He said that we are securing our own tech stack and hardware infrastructure to make our new content delivery network uncancelable, right? So this is one of those things that if a certain client of a certain large technology provider calls up and says, hey, we're an important client, we don't like those people over there on the same stack, you have a choice, right? We can pull our account or you need to boot them.
mm-hmm.
And if you are a major player, guess who's going to get booted, right? If you're a minor,
the dissenting voice gets booted, and the big advertiser has wielded their leverage to silence a particular voice that they don't like.
Yeah. From the legal side, so we go back in time and you look at what happened to Parler, right? So they're completely smoked. I mean, they're taken off of everything, and they had contracts. They had signed contracts that everything was in the up and up and everything was up to date, and they're just like, sorry, breach a contract, but what can you do, right?
Mm-hmm. I think it's interesting when you think about the migration from the traditional soapbox in the square in England, where people climb up on a box and talk about whatever it is that's on their mind, which in some ways has its in some ways the foundation for our Second Amendment.
Mm-hmm.
And when you think about traditional U.S. notions of constitutionally protected speech and how that works in a public forum, and then you take those concepts and try to bring them into these private spaces, which have become the functional equivalent of the square in terms of discord and dialogue, it raises some really interesting questions about freedom of speech, not on a constitutional dimension because you don't have state action, but constitutional speech from a principled perspective, which is the Constitution really defines what we believe is right and fair, which is as long as you do it in a way that isn't affecting other people's rights, you should be able to say whatever you want to say. And the community should judge you for what you're saying. And if you've got an audience that is interested in your content, you should be able to share it. And the big bad wolf shouldn't be able to shut you down because what you're saying is politically unpopular or contrary to what a big corporation wants people to hear. And so I think, even though it doesn't rise to a constitutional dimension in the absence of state action, we all have these notions of fairness when it comes to what a platform should and shouldn't allow and what's in bounds and what's out of bounds. And I think part of the issue is, and you mentioned Nunes, Part of the issue is that the politicians have taken to these platforms to disseminate all manner of nonsense. Not that the idea that politicians lie is new; they've been lying since the first election was ever held. The real issue now is they've done such an intentional job of flooding the lanes, which was the strategy from the first election. It's now so hard for people to discern the true from the false. And so, in some ways, they're looking for their platform partners to help protect them from what they would consider to be um, inappropriate or unbeneficial content. So, the platform provider has to walk this line between I want to have as much of an open forum as I can because I think everybody believes in an open principle when it comes to platforms, particularly content platforms. But also, I've got to protect the baseline of customers that says, I'm not going to be on a platform that permits X or
Right.
Y or won't take down.
Yeah.
I've heard, in the context of content related to, for example, criminal activity, even sex trafficking,
Yeah, or pornography, right? I mean,
and
yeah,
pornography,
yeah, all
right?
that, yeah.
So it's really a difficult line to draw. And so often what I've seen now is that when it comes to content, a lot of the lines are being drawn along political lines, and which concerns me because in America, I feel like we have state-run media, but we have just two stations. In Russia and China, you've got state-run media, but there's only one channel. In America, you've got state-run media, but each party has their own outlet. And as you start dividing up how you're going to moderate social media and other platforms along political lines, then you wind up with something no more democratized than the monopoly of media that we're experiencing in the United States. And so I get a little concerned when there's a close alignment between social platforms and political influence and content, because particularly in an election cycle like we're in right now, that becomes a critical part of the user experience.
So speaking of monopolies, it's recently been raised by David Sachs, a famous, VC entrepreneur, billionaire in Silicon Valley, about Google's monopoly in video and in search, and even point of office suites. In particular, the concern is, again, kind of some sort of biased approach, right, to this election cycle, that then somehow, some way, public internet, such as the search engine, which garners literally information data from all over the globe publicly, is now somewhat being controlled to show a biased outcome.
Mm-hmm.
In your opinion, in your expert opinion, is there a case there for something like this to take place, where an antitrust law could potentially come down and break up the monopoly that Google has?
I've been limited to antitrust and stay away from the political part for a moment. Any business that rises to the level of market dominance as Google, they've got a whole department of antitrust lawyers. So they for sure are concerned about antitrust, and antitrust is a huge part of their whole legal, metrics of what they're focusing on. I would say that for me, there's a difference between a natural monopolist like Google, who started in a garage and developed a tool that we all thought was pretty cool when we started using the internet to organize our homepage, that turned into a media giant that then expanded into these other areas where there was competition. Let's be frank. I mean, when Google started its collaboration platform, Microsoft was already there.
Mm-hmm.
When Google started its YouTube TV concept, plenty of competition was there. And so I look at Google, and aside from engaging, allegations of engaging in anti-competitive behavior, at a high level, in my mind, what they've done is not only legal, but admirable. I
Mm.
mean, they're one of the, they're the modern equivalent of the Industrial Revolution. These guys are like Rockefeller, from
Yeah.
past generations. So in a lot of ways, I admire them. I'm not saying they haven't engaged in any anti-competitive behavior, and if they did, that's wrong. But there's a difference for me between a company like Google and a company like AT&T or any of the utilities or anybody who's been placed in a monopolistic position because of government regulation or otherwise. And to me, anytime you have a government created monopoly that is being protected by government, that is prohibiting potential competition, that's a different kind of risk to me and a different kind of legal question for me when it comes to antitrust than a natural monopolist like Google. But I would tell you, they're all worried about it. Anyone who gets to a level of market dominance, even in a subcategory, take Adobe, for example.
Yeah.
There was a time that Adobe had such a stranglehold on the computer aided design market that they were a monopoly. And therefore, they too had a big department, and still do, I'm sure, of antitrust lawyers, because you can succumb to the gravity of your own success when it comes to antitrust. And in my mind, there's a difference between those that come about it because their product is so good and they dominate naturally. Even though there's opportunities for others to come in, they've created an environment where they won't or can't. Some of that is to be respected and admired, but it does put in their hands a great deal of power, and it needs to be checked because when they get to that position, if they start engaging in conduct that's anti-competitive, then that would become actionable under the Sherman Act. And trust me, there's lawyers that are either bringing those cases or considering bringing those cases against these entities on a regular basis.
That's a bridge to something I wanted to talk about, but you make a valid point that I think Google is evidence of, that even with your dominant position, if a majority of your energy is being spent on constant improvement versus energy on sharp elbows to keep the competition out, right? So as a consumer, as long as my consumption experience continues to get better, I'm happy, right? And I think Google does do that really well. But that brings me to something I wanted to go back on the legal side, which is, look, I come from Wall Street, and there's certain intellectual property that we would create on the investment side, and you would try to get it protected because it was unique and so forth. And all the way to other people that have typical brick and mortar, which is an even more definable IP. But man, on technology, it moves so fast. So what's the piece of advice you can give to these young engineers that can make code do anything? They're constantly trying to solve, like you said, create something that serves 500 people and you can blow it up to 50,000. So from the legal side, what is something that you can communicate to these young people that would be beneficial?
Well, I would say number one, you have to think about the code, right? You think of it as a tool to make something, to make a computer do something. But really, that code is the product. That code that you're writing is the IP. And so, as the developer, the number one thing you need to do is make sure there's no cloud on the title of that code.
Hmm.
And what that means is you don't just go grab snippets from here and there and plug them in and put it together, stuff you didn't write.
Yeah.
You don't combine open source components with non-open source components and compile them in the same compiled solution, because then you just put your proprietary code into the open source.
Right.
So if you think about what you're writing not as something to make something happen, but as the product itself, and when you understand that you're going to need a copyright on that, you're going to need agreements if anybody else is touching that code to make it clear that they don't have any right to those codes. So, being careful even in the beginning stages about who you let write on your software and contribute to it, and make sure that you have the appropriate work made for hire agreements in place with all of those developers. But the idea is that, your software code is like a house. And if it goes well, there will be claims to title. Think of the Facebook Winklevoss twins litigation. That was a fight over who owns the software, right? And those fights happen often. And the more successful your software is, the more likely it is that you're going to have that fight. So you want to be able to demonstrate, A, you wrote it yourself. B, anyone who wrote it for you has got a signed and enforceable work made for hire agreement. And C, you haven't taken open source code and commingled it with your code, because that will come back to bite you in the end. So there's three things just about how you think about the code. And then, of course, while patents are available to software applications, the most famous one is called the time warp patent that was issued to pause, rewind, and record live television. Quite a cool patent to get. And I wish I had that one. But there are others. Amazon has the one-click checkout patent. But for most developers, patentability is no longer a viable course. The Supreme Court has significantly narrowed its view of patentability and patentable subject matter when it comes to software. And so for most people, software patents are not a viable IP protection, but copyright registration is. And so I recommend to all of my clients that they copyright their beta release of the software, and they get a new supplemental copyright registration for every main release. So if you think about dot releases and main releases, your 0.1 doesn't need a new copyright, but your 2.0 does.
Right.
And those are relatively inexpensive to secure and give you a lot of legal protection relative to not having a copyright. So those would be, four things to think about as a developer to make sure that you're not setting yourself up for a legal dispute down the road, and that you're also protecting yourself against would-be copycats who may get their hands on your code either because you trusted them to have it and then they violated your trust, or they came about it through improper means. The copyright protection is the strongest when it comes to being in the hands of the copyright owner and wanting to use it to prevent infringement activity.
Right. This was great. We'd love to have you back. And the good news about as fast as technology moves, there's always going to be something new and fresh to talk about from the legal side. So you're a good man. We really appreciate your time today.
I appreciate your time, and I haven't announced this yet, but I'll make this announcement for the first time on your show.
Nice. Here we go.
I am actually starting a podcast myself.
Nice.
And I would like to invite you guys to come on to talk about your virtual headquarters product and your communication tools that you're developing. So I'd love to reciprocate and have you guys on my show as well.
Yeah, excellent. We'd love to do it.
Okay.
Yeah.
All righty. Thank you guys very much.
All right,
Really
Rob.
appreciate
Thanks
it.
so much.
Thank you. Take care.
Okay. Bye.